All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Justin Bork, Joey Wayne Greer, CR 26-11. He's verified in custody in Rains County. I'll recall that case. Kiera Moffett, CR 2298. She's contacted the court this morning indicating that she's got transportation issues. She may be appearing at 1:30. Court will recall that case. Jacob Myers. Mr. Myers is set for sanctions court, has contacted the court indicating that he is ill. Court will recall that case. Ryan Norris. Keith Stevens. Aaron Vasquez Jr. Kiana Walker. Jalen Fairley. CR 25-131, Chase Allen Harrison. Motion for continuance granted. Docket call set April 28th. It's my understanding that there may be some subpoenaed records we'll discuss. I will recall that case shortly. Bradley Bearden. Sherry Roach. Thank you, Mr. Lawhorn. Clinton Tinsley. Thank you, Mr. Abraham. Christopher Yates. Thank you, Mr. Pointer. Christopher Wayne Blevins, CR 25-154, is verified. He was arrested in Kaufman County, I believe, yesterday. We'll recall that case. Wyatt Berkwin. James Buchanan. Ashley Bulow. Savannah Cooksey. Deanna Dial. Ashley Earlston. Susanna Frisbee. Joshua Gomillion. James Goodson. Zeepsek Gut, I believe he's going to be appearing via Zoom. We'll recall that case. Ronnie McGee, CR 25-135. I have him verified in custody in Smith County. We'll recall that case. Joseph Tudor. Christopher Watson. Mr. Watson's here? Okay. I had you in custody in Williamson County, but you're not in there. Were you in custody in Williamson County? Okay. Thanks. When did you get out? Okay. All right. We'll have to see why their system shows that you're still in there. Michael Weaver. Jalen Young. CR 25-224. Show that he's verified in custody in Caddo Parish. Court will recall that case. Cletus Pippin. All right. Is there anyone who's in the court and your name's not been called and you expect to be on the docket today? We have any counsel that's ready? Mr. Wells? Cletus Pippin, CR 25-11. All right, Mr. Wells, Mr. Pippin is set for a docket call today.
Yes, we intend to call these carrier, this accident, vehicle accident. And just yesterday, he received a letter from them saying that all claims and damages presented have been paid and settled. So I just need to sit down with Ms. Curry and see if we get it ironed out. I guess they're just not going to give us a release.
All right, court will set Mr. Pippin for final docket call. You available either the 23rd or the 28th?
It's fine.
28th. All right, court sets Mr. Pippin then for 9 a.m. on April 28th. Yes, sir. Thank you. Bradley Bearden, CR 25-195. Morning, Mr. Head.
One, we've reached an agreement, we can set it for a plea with the court.
How much time do you need?
Honor that, 28th day, be fine if that's available.
Will it be a morning plea or a afternoon plea? Afternoon pleas are reserved for those going into custody.
Honor morning time.
All right, court sets Mr. Bearden for April 28th at 9 a.m. for a plea. And once he signs his notice of appearance, he's free to go. Is that all you have, Mr. Head?
Yeah,
Court-
Honor, Matt, maybe.
Yes, thank you, Mr. Head. No, that's okay. I just want to make sure I got you taken care of. All right, this is cause numbers CR 25-222 and 223, State versus Christopher Matthew Yates. Set for docket call. Mr. Pointer, go ahead.
Morning.
Morning.
We had a wedding, for the session. And, I think we're going to ask in 45 days to make sure we get that in.
That's correct, Your Honor. I think 45 days should hopefully give us time to receive it and review it.
May 12th.
That works.
Okay. All right, court sets Mr. Yates then for final docket call, May 12th at 9 a.m. And so on that day, Mr. Pointer, I'll expect Mr. Yates to announce either plea agreement, enter a plea that day, or request a trial. You're welcome. Sherry Roach. Yes, this is cause number CR 25-213, State versus Sherry Raylyn Roach. All right, the court will set Miss Roach for docket call. The court will grant defense leave to file any late pretrial motions on the issue of restitution. Mr. Lawhorn, I've got those two dates in April, April 23rd, April 28th.
April 28th or the May 12th.
Let's do April 28th. Court sets Miss Roach then for docket call April 28th at 9 a.m. So on that date, I'd like to hear either plea or set for trial.
Yes, sir.
And the motion, if you,
Yes, sir. Yes, sir. And then if that happens, then we'll set it for an evidentiary hearing. You're welcome. Good morning. Counsel, your approach. Good morning. All right, this is cause number CR 25-131, State versus Chase Allen Harrison. The court had Mr. Harrison set for docket call today. A motion for continuance was filed by the defense, which was granted by the court, and the court reset docket call till April 28th. However, I believe that motion for continuance was based on the production of subpoenaed records from the Department of Family and Protective Services. Is that correct? And so today, those records are being tendered to the court for in-camera inspection. Is that correct?
Yes.
And your name?
Amy Castillo.
All right, Ms. Castillo. Okay, I'll go ahead and take those records at this time. Thank you very much. And you are relieved of any subpoena that you have at this time.
Okay.
Thank you, Ms. Castillo. All right, and so what we'll do is we'll just continue this as what's in the order to continue April 28th. Go ahead and have him sign a notice of appearance. And we'll do that, we'll do docket call, but we'll also do status of in-camera inspection. And I'll try to get these records reviewed. Now, I do want some type of scope from the state and the defense as to what the court should be looking for. If it's mitigating, if it's exculpatory, that's easy for the court to see. But if there's something that's very specific to a defensive strategy or something else that the state's aware of, that the court needs to be aware of, then if y'all will just maybe email me, do my coordinator, Ms. Abraham, and let me know, so I'll be able to focus in on my search.
Yes, sir.
Okay. All right,
Thank you.
Ms. Harkins. Thank you, Mr. Earl. Mr. Schmidt, are you ready? Who would you like first? Mr. Buchanan? CR 25-196, State versus James Larry Buchanan. I believe Mr. Buchanan is set for pretrial.
That's correct.
All right, court will place Mr. Buchanan on docket call, and the court will set him April 28th at 9 a.m. Yeah, we go move that microphone up so they don't hit it. Just move it up to the end. Who's next, Mr. Schmidt? Ashley K. Bulow, CR 26-8. And ma'am, how do you say your last name? Bulow, okay. And Ms. Bulow is set for arraignment.
That's great.
All right, the court places Ms. Bulow on the pretrial docket April 28th at 9 a.m. Finds that she has waived the formal requirements of arraignment and enters her plea of not guilty into the record.
Did you say the pre-trial court meeting?
Yes, sir.
Thursday?
Ms. Frisbee, cause number CR 25-230, State versus Susanna Aurora Frisbee for final docket call.
Already said, Thursday.
All right, how much time do you need, Mr. Schmidt? All right, court sets Miss Frisbee then for April 28th. And that's a morning plea. It'll be at 9 a.m. Joshua David Gomillion, CR 25-249. Mr. Gomillion set for docket call. I show Mr. Gomillion's delinquent on his pretrial release fees. Do you know when the last time he's made a payment? I show he's delinquent $120. He can pay 80 on Monday. All right, court orders Mr. Gomillion to pay $80 on Monday towards his pretrial release fees. You'll still be delinquent $40, plus you'll incur next month, so that'll need to be resolved. Court sets Mr. Gomillion for final docket call April 28th at 9 a.m. James Robert Goodson, CR 25-250. All right, Mr. Goodson set for docket call. All right, court sets Mr. Goodson for final docket call April 28th at 9 a.m. Who's next? Mr. Watson. Cause number CR 22-198, State versus Christopher Storm Watson. State's motion to adjudicate.
And, I think we're pretty. What, okay, so that on that 40.
All right, court will set Mr. Watson for hearing on the motion to adjudicate 4/28. And Mr. Schmidt, if he doesn't resolve it that day, he's going to go forward for evidentiary docket on 4/30.
For what?
4/30.
For the.
So he'll be here on Tuesday. If he doesn't resolve it, we'll have the hearing on Thursday. Ashley Ann Earlston, CR 25-245. Ms. Earlston is set for docket call. All right, court sets Ms. Earlston for final docket call on April 28th at 9 a.m. Yeah, let's do Mr. Tudor. Joseph Scott Tudor, CR 25-284. Yes. All right, court sets Mr. Tudor for docket call on April 28th at 9 a.m. and also for pretrial or for status on pretrial bib. Who's next, Mr. Schmidt? Let's see if this is him. I'm not sure this is him. It's an unidentified person in the Zoom, but perhaps. Mr. Good, if you can hear me, there you go. Looks like you just unmuted. Can you see and hear me okay?
Yes, I can, Your Honor.
Excellent. All right, I'm going to call your case, and your attorney, Mr. Schmidt, you can probably see him on the camera. You're good right there, yeah. You can probably see him right there. If you can't see him, if you're on your phone, you may have to swipe left or right to see more participants. But we are in open court, and your attorney, Mr. Richard Schmidt, is here, and he's ready to call your case. So I'm going to go on record at this time. This is cause number CR 26-12, State versus Zibasek Goot, and we're set for arraignment. Go ahead, Mr. Schmidt. Hang on. Grab that microphone. He might not be able to hear you.
We have to see the guideline, because his name is actually spelled correctly. We wait for you, and that's, everybody not.
All right. Court finds that Mr. Good has entered his plea of not guilty. The court places that into the record, finds that he's waived the formal requirements of arraignment, and the court will place Mr. Good on the court's pretrial docket for April 28th at 9 a.m. So, Mr. Good, that's the notice that you're going to receive is the one that you're receiving right now in open court, April 28th at 9 a.m. Mr. Schmidt has that, and you also your bondsman will be aware of it as well, okay?
Wait, that was April 28th, 9th?
April 28th, 2/8.
Eight.
That's a Tuesday
Yes, sir.
at 9 a.m.
9 a.m.
Yes, sir.
Okay, I got it.
All right, we'll see you on the
I got
28th.
it.
Okay, you're free to go.
All right, thank you, Your Honor. You have a wonderful day.
Thank you.
Thank you.
You're welcome. You're welcome. Have a good day.
God bless. You too. Thank you.
Justin Bork. All right, Mr. Bork, this is cause number CR 25-244. I reset you to give you time to hire an attorney. Did you hire an attorney?
He said short notice, he couldn't go make it today, previous, obligations, but that process of the name. Try to go to the later this afternoon and, go ahead, get the money, now. Sign on it or whatever.
Okay. All right, so what I'm going to do, Mr. Bork, is I'm going to reset you for Thursday this week. All right. So that'll give you the rest of today and tomorrow to get that business handled so that you can hire Mr. Weiner and so that you can be present on Thursday for arraignment.
Okay.
All right. So we're going to have you sign a notice of appearance and then you'll be free to go. Ms. Walker? This is a sanctions court hearing. Cause number CR 21-312, Say versus Kiana Denitris Walker. Let's see, Ms. Walker, at our last sanctions court, I ordered you to do a few things. Ordered you to pay $100 to probation. You did that. $100 to collections. You did that. It said you came up short on your 20 hours community service. Did you get 20 hours done?
I think that,
You know, so I think, to him, so maybe when he transfer my caseload, it will update it, but I have completed that each Saturday since I came to court. So everything is completed that you just that.
Okay. Where'd you do your community service? MLK? Okay.
I also
Yes.
respect. Give me the time that I come down here with, coming to work because I've been busy today and my job is strict. And right now, I'm still a temporary employee, so that's hindering my chances of being hired on full time and can involve in termination. I will continue to comply with within the parameters that you have set each month. And, I want to continue to do that. My plan is to be complete with all of my funds and community service by December 2026. Therefore, I will be clean and clear to complete my probation by 27. But I just don't want to lose my job by having to miss, this is the third month in the year so far, and I already have 200 excuses out. Have a 3.5 attendance policy, so I really don't want to lose my job by having to come to court, but I will continue to apply. I will continue to pay within the parameters, and every Saturday I'll be going to the.
Yeah, and I understand that concern, but I hear you. Okay, I hear you, but I want you to hear me as well. The reason you're in sanctions court is because you weren't doing the things that you were supposed to be doing on probation on your own. You've ended up here because you weren't doing those things, and this is an intervention basically to get you back on track so that you don't end up in prison. So the only reason I'm bringing you to court is because when we put you in the community, you weren't making your payments on time, you weren't doing your community service, and sanctions court is a correction program trying to correct your behavior from before. Otherwise, I wouldn't have anything to do with you, and you would be able to go to work and come and go as you please, as long as you were meeting those conditions. So I'm sensitive to your request, but unfortunately, you put yourself in a position that the community supervision department doesn't trust that you're going to do what you say you're going to do on your own.
And I was here, my fun, doing my community service, up until I hit the snag in my life. Like, everything is, everything's I'm trying to put everything back in place, so I can commit to doing that. And if we can just try that, and if I don't, then I can come back to court, but I really don't want to lose my job. If I lose my job, then I can't pay it again, and, like, I'm committed to finishing this. I mean, I only have 13 months left. I don't wanna go to jail, I don't wanna, be behind, I want all of this to be done, but I don't wanna lose my job in this process. I already hard, on the job, and I'm just now in a place where I'm trying to get out full time, and I don't think every month I'm missing, that's gonna be bad for me. I'll be back in this place, so I'm committing to trying, I'm trying, I'll continue to do that because I don't wanna be back here, and I don't wanna go.
And I don't want you to be back here, and I don't want you to lose your job either, and I don't want you to get it revoked. Give me just one moment, okay? All right, Ms. Walker, I want to make you a deal. Okay. I'm going to reset you for your next sanctions court. And that's going to be on April 28th. And there's three things I want to order you to do. You're going to have to pay $200 towards your probation fees. And that's the amount that you have to pay each month in order to expire on time. Because you're behind, you're delinquent in those, right? So that's the amount that you have to pay if you want to finish on time without an extension. You have to pay $100 to the clerk's office for the court fees, okay? And then you have to do your 20 hours of community service, the same as last time. And you have to work 20 hours every month because that's what it's going to take for you to complete everything on time, okay? So what I'll do is, since you were in compliance, and we're gonna have to verify your 20 and a half hours. I want to take your word for it, but we've got to verify that. I will have you report. Go ahead.
Didn't know if they started, so I didn't know if they didn't do up there, but I have more.
Yeah, yeah, bring it in here and you can give it to these probation officers and they'll scan it and make a record. And that may help them be able to verify it faster. Okay. And so that's going to be on April 28th. And here's the deal. I'm going to let you report via Zoom. Okay. You understand what I'm saying? I'll let you log in on your phone. It'll take 5 minutes or so. That way you can keep your job and keep complying so that we can work towards this common goal. And my goal is your goal, to get you off community supervision without being revoked. Okay. But here's the deal. Okay. That's what's in it for you. What's in it for me is if you're short on any one of these, then we're right back to in person. So if you don't make your payments on time, you don't get your 20 hours done, then we're just going to come back to being in person and you'll have to figure out the job thing. Is that a deal?
Like, how we can do it on Saturday, would it be 4 hours? I mean, 4 Saturdays. Sometimes it might be 16 because it's 8 is.
Then you might have to find somewhere else to go to get 4 more hours. Yeah. So community service isn't your convenience. It's the community's convenience. So you go find places to serve, and there's going to be places during the week. It just has to be an approved place. So if it's a church or a youth center or whatever, you just make sure that it's approved and then go find that until you get your hours. You're in Dallas County or Van Zandt County on community service.
Maybe give it to both.
No, place where she does it, where approved places come from, Dallas County or Van Zandt County.
Either.
Okay, so there should be a lot of opportunity in Dallas because there's going to be a lot more places up there, I'm sure, that are nonprofits that qualify for that kind of community service. Just don't go and spend your time working and making an assumption that it's going to be approved. Get your approval first and then go do the hours. Does that make sense? Okay. All right. So April 28th. So you're going to Zoom in. Miss Patty there will give you the Zoom ID information. And then you'll have to log in on your phone and just get in the waiting room and you can keep on working. And when I'm ready for you, I'll send you a message that says, hey, turn on your phone. And that'll be your cue to let you know I'm ready. You step out, take your break, do whatever you need to do, and then we'll have the hearing. Yes, 9 a.m. Patty, let's do this. Put 10 a.m. We'll put 10 a.m. on it so that you probably won't even be waiting. Just go at 10 a.m. and I'll probably be able to get right to you. Okay. Yeah, bring it back in here and give it to these probation officers. You're welcome. Mr. Schmidt, who are you ready on? Miss Dial, Is this gonna be a plea today?
No,
Okay. All right, this is cause number CR 25-129, State of Texas versus Deanna Joyce Dial. Announcement.
um,
All right. And what offer was extended that's been rejected, if any? So 2 years. Was it a conviction or a deferred? So 2 years deferred community supervision on a Class A misdemeanor assault. And Ms. Dial understands that the court may not allow her to engage in plea negotiations after today.
Yeah.
All right, the court then sets Ms. Dial for trial. We'll begin that on Monday, April 6th. And so, Ms. Dial, you will here at the courthouse on April 6th at 8:30. You won't be reporting to the courtroom anymore until your case is reached for trial. You'll come into the courthouse. My staff will be downstairs. They'll talk to you about your reset date. Pretrial officer may be down there. You'll do that. Mr. Schmidt won't be required to be here on your case unless it gets into the top 10, and you'll be notified. He'll be notified when that occurs. Okay? You're welcome. Mr. Sanders, you ready? Mr. Norris, this is cause number CR 25-270 and CR 25-271, State versus Ryan Dwayne Norris. And we are set for pretrial.
Yes, and we don't have any trial issue, did that look at all, the discovery, we're still talking, that we could have this set, or I guess not call, next setting.
All right, I've got either Thursday, April 23rd or Tuesday, April 28th.
Let's go with that.
Okay. All right, court sets Mr. Norris in for docket call April 28th in each case. Once he signs his notice of appearance, he is free to go.
Thank you.
You're welcome. Okay, Mr. McGrath. Mr. Vasquez? Oh, I'm sorry, I'm sorry. I'm sorry. I saw you walk, no, I saw you walk out and I didn't see you walk back in. So I thought y'all went outside to have a discussion. And so I was just going to move on to the next. All right, court calls. Cause number CR 25-238, State versus Clinton Ray Tinsley. We're set for pre-trial today. Any announcements, Mr. McBride?
Mr. Calls to assess the decision to go to trial.
Okay, and there's no issues with evidence or pre-trial issues, correct? All right, court will set Mr. Tinsley then for final hearing on docket call. That'll be April 28th at 9 a.m. So on that date, Mr. McBride, Mr. Tinsley will have to make a decision whether he's going to enter a plea agreement that date. If he is going to enter, then you need to contact the state so that they can have the plea agreement ready. If there's no acceptance on that date, then the court will place Mr. Tinsley on the court's trial docket, and then we won't do any negotiation after that. Okay? You're welcome. And we'll have you sign your notice of appearance. Are you filling that out, Patty? And then once he signs his notice of appearance, he's free to go. All right, Mr. Vasquez, we'll try again. Come on up. All right, this is a sanctions court hearing for Aaron Vasquez Jr., CR 21-394. All right, Mr. Vasquez, I see that the last time I ordered you to do a couple of things. They were for you to, looks like you completed your polygraph and that was successful. Looks like you paid your remaining balance that was due on your April assessment yesterday. That's great. It says that you haven't worked any community service. Is that right? Okay, good. And then it says you haven't had any payments since August of 25. But I'll tell you what, I'll cut you a break on that right now since you've gotten caught up on what you owed Mr. Motley. So what we'll do, Mr. Vasquez, is I'll bring you back on April 28th. And I need you to do two things. I need you to pay $100 to your probation fees. And then I need you to do 25 hours community service. Are you working right now? What's your work schedule?
It's funny, big problem.
Okay, so so you've got the weekends to be able to work your community service?
Yes, sir.
Okay, all right, so. So I'm gonna change it to 20 hours of community service, okay? Instead of 25. So 20 hours community service, $100 for probation. Do that before April 28th, and we're gonna come back to court on the 28th, okay? Ms. Abraham's gonna have a form for you to sign. Once you sign that, you're free to go. No, it's updated on my records that you paid, so that's good enough for me. Mr. Sanders, you're not waiting on the court, are you?
Yeah.
Okay.
Okay. There.
Okay, that's fine. That's fine. Mr. Greer, come on up. On record, cause number CR 26-11, State versus Joey Wayne Greer. Mr. Greer, you've been indicted with the second-degree felony offense of possession of a controlled substance in penalty group 1 or 1B, greater than 4 grams, less than 200 grams. That is a second-degree felony, which does carry a range of punishment if you were to be convicted and sentenced to not less than 2 years in prison or more than 20 years in prison, and a possible fine not to exceed $10,000. Do you intend to hire an attorney to represent you in this matter? All right, I'm going to reset you to April 28th. Do you believe that you'll have an attorney hired by then? All right. Court sets Mr. Greer then for arraignment on April 28th and status to hire an attorney. Ms. Taberham's going to have a notice of appearance. Sign that and you're free to go. You're welcome. Is your attorney Mr. Schmidt? Okay, all right. Keith Edward Stevens, CR 2514. This is a sanctions court hearing. All right, Mr. Stevens, unfortunately, I believe that there is a warrant for your arrest today. So you're going to be taken into custody at this time by Sergeant Martinez. And I believe it's a revocation warrant from probation. Yes, sir. Court is going to set Mr. Stevens. Let's set him on April 23rd. So, Mr. Stevens, I'm going to set you on April 23rd. If you're going to be requesting a court-appointed attorney when you get to the jail, make sure you fill out that paperwork. It'll be sent over here. If you are indigent, then the court will appoint you an attorney, and then we'll come back on the 23rd and see if we can't figure out how to resolve the issues, okay? All right, court is going to take a recess so that Mr. Schmidt can finish talking with his clients. Court will stand in recess for about 30 minutes. So we'll check in a little bit before 11. Court's in recess. Mr. Carpenter, are you and Mr. Fairley ready? Mr. Fairley, if you'll come forward, this is cause number CR 25-199, State versus Jalen Jamal Fairley. Set for final docket call today. Any announcements?
I guess, Your we're gonna want to set it on a plea docket. There's well, this is that we need to work it out, and I think the state is a little bit, states that you are all agreeing that there's possibly a date in May. If we can have that day, that's available.
What's the reason for the long reset?
It's gonna be some time in jail as a condition, and so working out, we get some work schedules, making sure that it's all planned out. We just wanna make sure that Mr. Fairley has enough time to properly plan that out.
I've got May 12th. May 12th?
Yes, that's fine.
All right, court will set Mr. Fairley then for plea before the court May 12th. And that will be a 1:30 plea?
It'll be a morning, please.
Morning plea.
Be scheduled for after.
All right, court sets Mr. Fairley for plea before the court May 12th at 9 a.m.
And say, to be clear, that doesn't mean we're going to jail that day, or that we need for correct. Gotcha. All right, yes, thank you for your time today.
You're welcome. You're welcome.
We'll see you back on May 12th.
Yes, sir.
Yeah.
Mr. Schmidt, you ready on anyone? All right, Wyatt Berkwin. All right, Mr. Berkwin's plea today, is that correct? All right, this is cause number CR 24-128, State of Texas versus Wyatt Lane Berkwin. Mr. Berkwin, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thanks, sir. You can lower your hand. All right, Mr. Berkwin. It appears that in your plea agreement today, I can get my computer to work. You are pleading guilty to a third-degree felony offense of burglary of a building with a controlled substance present, which would carry a range of punishment of not less than 2 years in prison or more than 10 years in prison and a fine not to exceed $10,000. It appears that upon your plea of guilty to that offense, the agreement is that the state would be recommending that the court consider the evidence but not convict you, and placing you on deferred community supervision for a period of 2 years with a restitution of $901.25, with your sentence in this case to run concurrent, meaning at the same time, with your Smith County case, cause number 241-0190-24. You would also be ordered to pay court costs of $290 and reimbursement fees of $500. Mr. Berkwin, is that your understanding of the plea agreement? Are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney? Do you understand everything that you've read and signed in your plea agreement? Mr. Schmidt, do you believe your client to be competent, and if so, that he's entering into this agreement intentionally, knowingly, and voluntarily after understanding his rights in this case? All right, Mr. Berkwin, I would ask you at this time, how do you plead to burglary of a building with a controlled substance present? Are you pleading guilty to that crime because you are in fact guilty of committing that crime? Has anyone threatened you, forced you, or pressured you to plead guilty? Court does accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the evidence being offered? The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, all that, beyond the, special institution state will not receive any other communication from the victim stated.
Thank you, Mr. Hartwell. All right, court will review the evidence at this time. All right, anything further from the defense? All right, based on the court's review of the evidence, there is enough evidence to convict the defendant of this offense. The court does follow the plea agreement. Court hereby defers the finding of guilt on the third-degree felony burglary of a building. The court places the defendant on 2 years community supervision, orders him to pay restitution of $901.25, orders that he pay court cost of $290 and reimbursement fees of $500. And the court orders that this sentence run concurrent with Smith County case number 241-190-24. All right, Mr. Burke, when you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence, I'm gonna have you come over to be fingerprinted. Who's next, Mr. Schmidt?
So.
Savannah Mae Cooksey, CR 22-93. Is Ms. Cooksey a plea as well? All right, Ms. Cooksey, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. You can lower your hand. Your name is Savannah Mae Cooksey, is that correct? Ms. Cooksey, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney? You understand everything that you have read and signed in your plea agreement? Do you have any questions about anything else? Mr. Schmidt, do you believe Ms. Cooksey to be competent to enter into this agreement? And if so, that she's doing so intentionally, knowingly, and voluntarily after understanding her legal rights? All right, Ms. Cooksey, I see that you are charged by indictment or information with a Class A misdemeanor offense of theft of property greater than $750 but less than $2,500. A Class A misdemeanor carries a range of punishment of not more than 365 days in the county jail and a possible fine not to exceed $4,000. I see the plea agreement in your case is upon you pleading guilty to this lesser included offense, that the state is recommending that your punishment be assessed at 20 days confinement in the Van Zandt County Jail, for which you would receive credit for all 20 days served. No fine, no restitution, court cost of $270 and reimbursement fees of $675. Is that your understanding of the plea agreement? All right, at this time, I would ask you, how do you plead to theft of property greater than $750, less than $2,500? Are you pleading guilty to this crime because you are in fact guilty of committing the crime? And has anyone threatened, forced, or pressured you to plead guilty? Court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the evidence offered?
No.
Evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, will be normal cases and very big services. In this case, it's the victim is the state of Texas. That process worked out a little bit different, but the state is in compliance.
Thanks, sir. Anything further from the defense? All right, court's going to review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court does follow the plea agreement. The court hereby convicts the defendant of theft of property, Class A misdemeanor, assesses punishment at 20 days confinement in the Van Zandt County Jail. The court orders 20 days credit for time already served. In addition, the court orders the defendant to pay court costs of $270 and reimbursement fees of $675. Ms. Cooksey, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. After we get your fingerprint today and I sign this plea agreement and judgment, you'll need to report to the clerk's office. Are you paying in full today for your reimbursement fees? Then, okay. Okay, then you'll need to report to the clerk's office today and discuss a payment arrangement with them, okay? All right. You're hereby remanded to the custody of the sheriff's office. So come over here and see Sergeant Martinez, and he's going to take your fingerprint. Michael Weaver, cause number CR 25-260 and 261. Mr. Weaver, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. All right, your name is Michael Dwayne Weaver, is that correct? And Mr. Weaver, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney? Do you have any questions about the paperwork that you've read and signed? Mr. Schmidt, do you believe Mr. Weaver to be competent, and that if so, that he's entering into this agreement intentionally, knowingly, voluntarily, after understanding his legal rights?
Yeah.
All right, Mr. Weaver, I see in cause number CR 25260, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram. I see that there's a plea agreement. Upon you pleading guilty to that lesser included offense, the state's recommending that your punishment be assessed at 15 months confinement in the state jail division of prison. However, they're recommending that that sentence be suspended today and for you to be placed on community supervision for 3 years. You would also be ordered to pay a $1,500 fine, restitution of $180, court cost of $290, and reimbursement fees of $535. As part of the agreement, the state's also agreeing to dismiss indicted costs CR 25261, which is your tampering with physical evidence charge. Mr. Weaver, is that your understanding of the plea agreement and what you're asking the court to approve? All right. At this time, I'd ask you, how do you plead to that offense? Are you pleading guilty because you are, in fact, guilty of committing that offense? And has anyone threatened you, forced you, or pressured you to plead guilty? All right. Court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the evidence is offered?
No.
All right. The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state?
Nothing.
From the defense? All right. Court will review the evidence. Was there a, is it trace amount of methamphetamine or is there a quantifiable amount?
That, because it's just, it came out to just over 1 gram. So when you include that leeway for, margin of error, with Brandon and,
Okay, but there is a quantifiable amount and the defendant did receive that.
yes.
It's just not included in the stipulation, so, okay. All right, then based on the evidence, the court finds that there is enough evidence to convict the defendant of the offense. The court will follow the plea agreement. Court hereby convicts the defendant of the state jail felony offense of possession of controlled substance in penalty group 1, less than 1 gram. Court assesses punishment at 15 months confinement in the state jail division of TDC. The court suspends that sentence, places the defendant on 3 years community supervision, orders the defendant to pay a $1,500 fine, $180 restitution, $290 court costs, and $535 in reimbursement fees. The court does dismiss under section 1245, cause number CR 25261. I'm sorry, that's not a 1245. That's just a straight dismissal. Is that correct? Okay. Court does hereby dismiss that case as being part of the plea agreement in this case. All right, Mr. Weaver, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come over to be fingerprinted. After that, you'll meet with the probation officers. All right, court call CR 25-224, State versus Jalen D. Young, and we're set today on, I believe, status. We still have Mr. Young confined in Caddo Parish. Any update from the state?
Yes, Your Honor. I've been having a little bit of difficulty getting calls back from the different parishes in Louisiana. What I am able to confirm is that it does have felony drug and felony weapons charges there. That appears to still be, in a pre-trial, state. What, if the court would allow, if we could do like a 60-day reset, and what I'll do is I'll just print fresh criminal history, right prior to that setting, to see if I can see what resolution, if any, there is. Just because we're having trouble leaving voicemails and not getting calls back.
All right, any objection from the defense? All right, court will set Mr. Young. Tuesday, June 2nd. Court calls cause number CR 25-135, State versus Ronnie Earl McGee. We have this set for status of his custody in Smith County. Any updates from the state or the defense?
Your Honor, I'm not sure where Smith County, is with their prosecution. At some point, we would like to have them back. I don't know if they would want to go again more, but we do intend to pursue our case, whether prior to Smith County finishing theirs or after, whatever ends up working out, but, we do intend to maintain our case.
Mr. Heron, do we know what he's in custody for over there?
Your Honor, it's the exact same charge.
Indecency?
It's,
Okay. All right.
I guess I can say different, or same charge, different on state.
All right, court will set Mr. McGee June 2nd. For status. Court call CR 25-154, State versus Christopher Wayne Blevins. And Mr. Blevins, we show that he was arrested in Kaufman County yesterday, I believe. Yeah, charging agency was the Denton County Sheriff's Office. Arrested by Terrell PD for assault causes bodily injury. So we'll reset Mr. Blevins. We're gonna set him on April 28th. He may not have the same length of stay as these other individuals. And the court is going to find Mr. Blevins' bond to be insufficient this time. So court will issue a warrant, issue an order requesting a warrant be issued. All right, I believe Kiera Moffitt is set for arraignment today. She's the one that I announced earlier was having car difficulty. That's what she communicated to the court. And so we expect her to be here at 1:30. Is that correct? All right, and I believe that does conclude the court's morning criminal docket. So court will stand in recess. We will resume at 1:30 from the Justice Center. Yeah, let's go ahead and call her name in the hallway, Sergeant Martinez, and I'll take it under advisement until 1:30, see if she shows. All right, for the record, cause number CR 20-298, State versus Kiera Monique Moffitt. Ms. Moffitt did not appear as ordered at 9 a.m. She's not appeared at any time prior to 11:40 a.m. The court hereby has had her name called loudly, distinctly in the courthouse with no response. The court is going to take the issuance of a judgment nisi and alias KPS under advisement until 1:30. Mr. or Miss Moffitt appears and the court will not be issuing the warrant. All right, court's in recess till 1:30.